application for leave to appeal and in the heads. But let me start with the referral affidavit itself. So it is in volume 5. So the page 387. Paragraph 42. So that was the pleading. The pleading relied on section 3.1 and as interpreted there. And you can see that that's a simple interpretation of the section, which is economic activity having an effect. Then that's in relation to the pure incola. Then you go to the first class Peregrini, page 388, paragraph 45. Now again, you have the same language there that is used, pure section 3.1. The second class, paragraph 48, page 390. And then page 391, paragraph 51, in relation to the pure Peregrini. So the pleading before the tribunal and before the CAC has been consistent with the arguments I am making today, which is there is jurisdiction because the economic activity complained of has an effect in South Africa. So that has never changed. This is not a new case. Now, you then get into the Competition Appeal Court in the argument. I specifically raised there that the correct construct of section 3.1 is a construct that's divested of the common law constraints. The judge has obviously dismissed that. Justice Dennis Davis refused to entertain the argument, and then he obviously dismissed it. So I'm entitled now to say, before the Constitutional Court, my pleading was correct. The jurisdiction of the tribunal was established, as alleged at paragraph 51 in relation to pure Peregrini, 48, 41 in relation to the incola and the local Peregrini, which is just a straightforward interpretation of section 3.1. So there can be no question that they had no notice. They knew, because that's the case we ran from the beginning.
No, I'm not talking about notice. My understanding of the respondent's argument is that once the CAC won, rejected your argument and came up with its own interpretation, which you do not agree with.
Yes.
You should have appealed, but you did not do so. And now, before this court,
Yes.
you are now rising at that point.
Yes.
And I think that's what I'm trying to understand from you.
Yes.
And they say you can't do so now and ask us to then interpret that section.
Yes. All right. Well, and I understand.
Go further and say, in fact, what the commission did was to then try and comply with the order of the CAC1 and then prepare the referral and the affidavit that was filed subsequent to that judgment.
Yes. Yes. On that second question, I've just shown that the referral sources jurisdiction from section 3.1. It's expressed in relation to all of the respondents, so on that second question. Then on the first question, should we have appealed or not, there can be no requirement that we should have appealed the 2020 order, which was midstream. It was an order to tell us to plead the case, and it was in a midstream, which we did. But this is a question of jurisdiction, it's a question of law, pure question of law. Even if it was not this case, it had...
I'll call you back. Something about it being frozen.
Yeah, it's frozen because I switched it off.
So why didn't they call him?
I don't know. You are the operator. Tell them.
No, but I put in the group DJ too.